I've ever given my whole life. No. No,
Nowadays, like the damage is so expensive, just like hit a turkey and it's gonna be.
it's all
$4,000.
plastic. It's all plastic,
Yeah.
you know, but he did get my radiator with his little nubs, you say?
Button back.
Okay, yeah, so my radiator's laying all over the, so my radiator came all out and my dog goes, it's gas, get the kids out of the car. And it's like rush hour. It was just not
Just
good.
gets better.
It just gets better, yeah.
On
Nice.
that note, it's about one. Time to get going, I guess. So we'll call this to order. Welcome to the December 21, 2023 meeting of the Abandoned and Discontinued Roads Commission. Postponed and continued from December 19th when we were originally going to hold this. This building had been closed and you can see it's open here. And for those of you who were able to make it, great. For those of you who are online, thank you for joining. I think we all have stories of what's happened the last few days, and it's been difficult and continues to be difficult for many people. So thank you for taking part in today's meeting. We could have a call of the roll, Heather.
Sure. Carla Black. Here. Brian Bronson. I don't see him online. Peter Coughlin.
Here.
Rebecca Graham. Rebecca, can you hear me?
Yeah.
James Cassiafikis.
Here.
Chris McCabe.
Here.
Roberta Manter.
Here.
Vivian McHale. Here. John Monk. Catherine Nadeau.
Nah. No, I'm here.
Thank you. Ryan Pelletier.
Here.
And I don't see Steve Young.
Well, it's a pretty good showing considering the circumstances. Thank you all for being here in person or remotely. First item would be the adoption of the minutes from December 6th. Has everyone had a chance to take a look at those?
No.
And Roberta says no. Do we want to just hold that off until the next time we meet? No one will get too mad at us. That be appropriate, Roberta?
Yeah.
Okay. Does that sound okay, everyone?
Sure.
Okay, so let's postpone those to the next meeting. Give everyone a chance to look at those. All right, so that brings us to the next item on the agenda, which is a public hearing on the draft report. Before we get started on that, with Heather's assistance putting together a template, we put together a draft report. We owe a report. It's actually January 5th. I took a look at the statute, January 5th to the State and Local Government Committee. So we put together a draft and some accompanying draft legislation. This is to try to get everything that we've been talking about on the table. It doesn't mean it's in final form. It's just something to react to, because otherwise we're just talking about ideas, and without seeing it on paper, it's hard to react to. We may not all agree with everything in here, and if there's disagreement and objections, then we should probably take those items and put those in the parking lot, discuss over the next year or coming years, because this is a standing committee. We're not going to solve all of the road problems of the state in one year. But if there are some things that we can find agreement on, we suggest that we act by consensus, which would be something that you can live with. It may not be your first choice, but at least can live with it. Understand that whatever we come out with for a recommendation in the report and for draft legislation is just the beginning of the legislative processes, as Catherine would attest to. It'll go to, if it becomes a draft bill, it would go to a public hearing. It would be before workshops. Other parties would have comments on it. And often what you come out with is not what you started with, and maybe not even remotely, and maybe it just dies in committee. So the idea is, what can we reach consensus on? So I just mentioned that before we go into the public hearing, because it doesn't, just because we have a draft report guarantee this is what we're offering and it doesn't have to be.
Just,
Chris,
Brian just texted me, he said that he's on there, but he's muted and doesn't.
Okay, is he
Oh,
yes, that's
DACY?
gonna be him.
Okay, then.
Yep.
okay.
Okay,
He's
thank
muted,
you.
And he said he can't get on with video. I think he
That's
just said.
okay. I think as long as it's good he's here.
Uh,
I can unmute him if
says
you want.
the video blocked, he said. Yes,
We have a block.
he said, I am on here and can hear, but she has muted and video blocked.
No, I have him unmuted.
You just did though. It was blocked till 2 seconds ago. You hear me now?
I did
All right.
mute you. I wasn't sure who you were, but
Neither am I these days.
I know the feeling.
Oh,
Is it still saying, do you want me to ask you to start video? Is that?
I
it's
don't
saying-
care. I can
I-
see you. That's
Okay.
fine. I can hear you. So
No, that's fine. I'll leave you, I don't need you on video. It's up to you. If you want to show your lovely face, I'd love to see, it, but if not, that's fine too.
so one other item before we start the public, hearing. How many people are on who want to speak?
I don't have anyone online, so
don't
I have,
think anybody knew that we'd moved the meeting. So
I-
when we moved it to-
I sent, well, the problem, people don't have power, but I did send out the listserv notification and I did update the website several times. So there's not much more I can do on that.
How many people have responded now on the listserv?
I have, I think, like 9 people.
That's
It's-
better, 'cause
it's
last
pretty
time I
good. It
asked
was-
you,
yeah,
I
it was
think
just-
there
it was 3.
Two.
So after I talked to you, then I had a bunch of people added. I do have one person's testimony that I included for you guys and I can read that. That they sent me. Do you know what I mean? And I think
I-
Kathy Mars here to testify.
Right, so let's go into the public hearing then, and, we'll open it up. Kathy, you'd like to be the
Sure.
first speaker?
Mhm.
Just
Thank
if you, state your name and address to the record.
Kathy Mott, 96 Bull Road in Cornish. So as most of you know, our neighbor put up a gate in July, blocking mine and my sister's access to our homes. There were no red flags. We all have the same written deeds. We got a building permit, mortgages, and title insurance with no problems. We tried to go through the town when things got heated. We went to many town meetings and the town refused to get involved. We contacted the MMA and I believe you were given the wrong information. So we had to go back to our lawyers. In July, our lawyer's fees were $17,000. We filed a claim with our title insurance company and they provided us with a lawyer. But the lawyer is contracted by the insurance company. So our say in all of this is minimal. We went to mediation. The paperwork is not yet finalized. But our neighbor is gonna get a rather substantial sum of money from the title insurance company. Which is horrifying to me. The road maintenance expenses will be split among us as well. Initially, our neighbors didn't even want us to be able to walk down the road that we live on. And then they relented, but as long as we don't dawdle in front of their house, we had to walk with force. We had to walk with force. We couldn't look at their house. So, which is in the agreement. Also in the agreement is that coming down my road, we have to go 15 miles an hour, then 10 miles an hour in front of their house, and then we can go back to 15 miles an hour. 15 miles an hour is a school zone. And my road is a dirt road. You cannot even go more than 20 miles an hour on my road. Roberta can attest to that. Another crazy thing. The whole thing is ridiculous. Again, our deeds all say the same thing. So in mediation, we said to our lawyer, how can this happen? And he told us, he's been doing this type of work for 40 years. More or less, get with the program. Because he said he was contracted to get us access to our homes, and this is how he was doing it. So so he said, either go with what he's doing, or we're gonna lose all of our equity in our homes, and we won't be able to get to our homes. So, on that note, I believe this is not a civil issue. I still think it's a state, it's a town issue. And when I called Pete, he was the head of all the local roads in the state of Maine, and he refers me to Roberta, there's something wrong with that. And our neighbor shouldn't benefit financially from this. And when I tell you a big sum of money, they're getting a big sum of money. It's ridiculous. So to me, you guys had talked about emergency legislation. This to me is an emergency legislation. Our lives are still not normal and they will never be normal. Not under these conditions. And I'm hoping that some of this legislation goes in 2024 and not 2025. Also, I've talked to my state rep, senators, tried to talk to the governor. Nobody wants to touch this issue. My state rep initially did, and then he backed way off. So it's just a horrible, horrible thing. I think everybody in the state of Maine should know what type of a road they live on and should be able to go home. So that's it. So, and it's still not final. Our paperwork still is not final. So maybe by the end of the year, it will be.
I agree with Kathy that access issues should be an emergency legislation. Because I see this too many times where one person just gets it into their head that they own the road. And no matter what the law says, they just say they own the road and they put up a gate and nobody will do anything to stop them. I think this should have been solved a totally different way. This road, in my opinion, clearly does not qualify for common law abandonment, which is what the neighbor is claiming. If it were common law abandoned, it would have trees leaning into it. It would have grass growing in the middle of it. It would be rutted so badly you can't drive down it. It would be impassable by a vehicle because nobody has used it in 20 years. If you look at aerial views, you can see where the properties on both sides of the road have been logged at regular intervals. You can, if you go on the records, you can find where the deeds say that they're in tree growth. And that means they had to file a tree growth plan. Local people have commonly used this road for access to get up on the hill to see the view. They've hiked in there on a regular basis. It's been used by a lot of people besides just the landowners. And my contention is that even landowners using a road should prohibit common law abandonment, because common law abandonment gets rid of the entire easement, private easement included. And that would mean that where there's a road that everybody's been using continuously for property access, you could just suddenly say that, oh, well, because the public hasn't used it too, now the private property owners have lost their access. That's not right. I say common law only happens when nobody has used the road. If nobody's using it, then yeah, let it go. Nobody needs it. It's not going to deprive anybody of access. If they haven't used it in the last 20 years, chances are they don't need that road for access. But on the other hand, I think this road clearly does qualify for statutory abandonment. The town admits that they never formally discontinued it. They also admit that they didn't maintain it for a 30-year period going up until the mid-1970s. And Jim, as I think you've said, that under 3028 abandonment was an automatic thing, that it's presumed that after 30 years if the road hasn't been maintained for public use, then it's abandoned. It's presumed abandoned. And that's what should have happened to this road. The town was ready to declare that. And at the last minute they said, but we should check with MMA first. And MMA told them, don't get involved. And I've seen this happen more times than I've seen towns that are ready to do something helpful. And then they say, but we should check with MMA. And MMA tells them, don't do anything. And then we end up with a whole mess and lawsuits and people spending money, and the dispute goes on and on. It doesn't get resolved. This is the thing that needs to be fixed. We've got people that are losing access because we can't get off our duff and do something to fix it.
Ryan, did you want to say something?
Yeah. I just want to remind everybody that this is a public hearing on the draft legislation. And quite frankly, I sympathize with all those individual issues, but I'm not here to hear those stories today. I'm here to hear comments about the draft legislation. And if we're not going to stick to the agenda, I'm not going to be part of the meeting.
Duly noted, Brian. Thank you. Do we have another speaker today?
I don't have anyone online. I have Frank Partridge who sent me an email, and I can read it if you want.
Let's do
Alright.
that, since in lieu of testimony, it's something that's submitted for this public hearing.
So this is Frank Partridge. He's a seasonal resident of Bucksport, and I guess we had heard Christina Ryberg and Donald Jewett last December. And this is his opposition to the Gullies Road public easement in Hancock County. He said, members of the commission, I'm writing to fully agree with the recommendations in your report to the 131st legislature, because I'm impacted by the confusion and complications of the conflict between public asset access and private property rights. I am also writing to deny claims made by Kristen Ryberg and Donald Jewett in their December 12th, 2022 letter to the commission about Gullies Road in Hancock County. They've made misleading statements that contend to be factual for their own personal advantage. They stated, we use a discontinued town road, the Gullies Road, for access to our land and cabin on Thurston Pond. This and later statements apply archaic, nearly completely unused roadway as a viable passageway, and more importantly, is their primary and prescriptive access, both of which are untrue. There are approximately 25 plus owners along a through road from Jacob Buck Pond Road to Bucks Mill Road. It has been there for 200 plus years. It provides access to many deeded properties. In my opinion, they omit that the Gristmill Road, they commingle multiple types of access, publicly maintained roads, publicly unmaintained roads, and town road, private road on private property with public access on a discontinued road into one deceptive class. There are 3 residents in the area, and only the Morrison resident is a full year home. The Gullies Road is 30 feet from his front door, has been nearly unused for 60 years as a common way. Ryberg and Jewett are seeking an alternative access via their Bucks Mill Road residence by way of Gullies Road to their pondside rental business. In paragraph 3, as a consequence, we found that we would not access our land or cabin, the Gullies Road. That misleads because the primary historical access is by the Gristmill Road. They have never been illegally denied access to their property. They proceeded to complain about attorneys and hidden agendas, but in August 2023 filed litigation against all landowners nearing Gullies Road, me and 10 other defendants, which seeks extending their access rights into private land and others unrelated complaints. That litigation is docketed with the Maine Superior Court and is yet undecided. It would be presumptive to believe that the outcome of the pending lawsuit will widely change the landscape of the challenges faced by the commission and the legislature. In addition to the authorized physical entry, eavesdropping and wiretapping, an intrusion claim can be brought for lying, misrepresenting circumstances in order to obtain entry or exceeding the consent given entry. Maine recognizes a common law right of privacy, which outlines 4 kinds of interest. Nothing is more needed than for the Maine legislature to define the process to achieve an inventory, class definitions, designations, rights of party, and providing a change process to preserve or modify the rights of landowners, as well as external users of the state transportation network. The work of the commission is a significant achievement. Sincerely, Frank Partridge. And he had attached several exhibits, which I had included in your guys' packets for today.
Thank you, Heather.
You're welcome.
Thank you, guys. Thank you.
Thank you. Okay, today's December 21st. In 2 weeks, we have a report due, because under LD 461, by January 5, 2024, the commission shall submit a report to the Joint Standing Committee on State and Local Government with the results of this study, along with recommended legislation. And that study is to review the use of the following terms in the Maine revised statutes: private way, private road, and public easement. So that's really been the focus of our work since March, to look at those terms and what they mean. And what we've done to date, we've got a listing of where those terms are used in Maine law. We've tried to look at each of those and see if they create confusion. And if they do suggest changes, we've discussed those. I tried to put those down in writing. I may not have been successful. We may not all agree on how to resolve that. So, but that's what we have. We have a draft report in front of us that's due in final form in 2 weeks. How do we want to approach this? Let's see.
I had a bunch of comments that I'd done up, which unfortunately I was unable to send out to people in advance because our internet is still down. Some of these are just, typographical kind of things or places where maybe a term appeared twice and you only caught it once, that kind of thing. If I can just go down through this kind of quickly, that'd be
Well,
helpful.
I don't know if that's going, how does the commission want to approach this? Because we have those terms that we have to, that the legislature has asked us to look at and answer. One, does it cause confusion? Two, if it does, how do you fix it? How would we suggest fixing it? Do we want to maybe just work through each term? Is that easier? There are certain terms that didn't cause any problems at all, it seemed. Like the term public way. It seems like nobody has a problem with the way that it is used in state law right now. That certainly the definition of way, they didn't ask us for, but it kind of shows up everywhere else. And so Pete had taken a look at that for us and we talked through that and it didn't seem like the term way was a problem. So then the question is public way. When we look at public way, there is a
Page are
definition.
you on?
Yeah.
No?
What page are you on?
Okay, take a look at,
not
oh, and of
quite
course,
following.
page numbers didn't come through on this. Beautiful.
Mine has page numbers. Do you have my
Page numbers.
packet, Jim?
I don't have your packet. I have what I printed myself,
Can
but
you pass that down?
okay, let's take a look at the,
Draft legislation.
okay, the draft legislation and also the draft report.
Do you want the draft report?
Yeah, if you've got numbers on that, please. Thank you.
I might not.
Yeah, that's what I was.
I don't. I'm sorry. I
Okay,
didn't
no,
have it
that's
on.
fine. I apologize. I should have had numbers.
I didn't catch that.
No, that's my fault.
So you want the draft
If you look at the
legislation?
discussion, the Roman numeral 3, there's a discussion, it's about 4 pages in. The Roman numeral 3 discussion, and it begins A, terms.
Draft report.
So I'm looking at the draft report itself.
Alright.
Look at Roman numeral 3 discussion. And then A is terms.
This is,
The next page is, it is number 1, item 1, way. And I think it's fair to say we did not find any confusion or issues raised by this term, its definition or its usage, and so we recommend no changes on that. I think that one's safe. We looked at that. It means the entire width, the clean boundary lines of the road, highway, parkway, street, or bridge used for vehicular traffic, whether public or private. Seems to take in the world and doesn't seem to cause any problem. So private way, I think we could probably spend 3 days on, so I'm gonna skip that right now. And move to number 3, a few pages later, public way. So you'll see the number 3, public way. Now, public way is also a broad term, but it's, if you think of it as a Venn diagram, way is everything. And a portion of the universe that the public has a right to pass over is the public way. So it's defined in the state highway law as a way owned and maintained by the state, a county, or a municipality over which the general public has a right to pass. So that seemed to be an appropriate definition. The only thing I'm going to throw out on this one is, does it include a public easement?
That's what I was wondering, because it says maintained by the public.
Right, and owned, and while the public may own a public easement, it doesn't own the road over which the public easement goes. That's owned by the private landowners on the side. So it does this include a public easement? I've seen some, as we've gone through all this, I've seen some areas where it suggests it might, and then areas where it doesn't. So that's maybe the only issue left there. Does it include a public easement? But otherwise, it seems like where there are specific other definitions of public way, like in the billboard law or the public safety statutes. They are narrowly tailored to just that section and don't seem to cause any confusion.
Rebecca has a,
Rebecca,
Rebecca, did you want to comment?
Yeah, I did. Jim, I'm kind of surprised by your take on that, considering the roads manual, which is, and the bar course on this, which lays out that the majority of main roads are easements and they're owned underneath that, but they're still maintained because of that historic way that they were created. So all public roads are public easements, but not all public easements are publicly maintained roads.
well, okay, I'll push back a little bit on that one, because while the earliest roads in Maine were proprietors' roads, they were the King's Grant, and in many instances, the fee, the ownership of the land went to the proprietors and then were deeded over to the towns, so that the town owns the fee in those. They're called rangeways, and those are some of the earliest roads in the state. Yes, since then, and until 1976, when the presumption was that new roads were laid out as, and the fee ownership went to the municipality after 76, when shown on a subdivision plan. In between, yes, they ride on a public easement of passage, but that's broader than just the public easement that we talk about with regard to what's left over after discontinuance or abandonment. And it's different than what we talk about when we lay out a public easement to just get to a recreational spot. It's, they're different animals. I understand what you're saying, and you know, we do say that it is these are easement roads, but they are different from what we have statutorily called a private way and then redefined as public easements in 77.
Now, does that mean that we need to have two different terms if we have one term that's meaning two things again? Isn't that what we're supposed to be avoiding the confusion on? Should we have one term public easement that means any place that the public has an easement for whatever purpose,
Well,
and another term public easement that refers to these specific types of roads?
well, let me, here's the point of confusion. When we say that most main roads between the King's Grant days of the 1600s and 1700s and 1977 are public easement of passage, those are all town ways, as opposed to a public easement. Those are town ways where the town has an obligation to maintain safe and convenient passage. And you can go to the county commissioners and have the town order to fix it.
But I think Rebecca would argue that that also qualifies as a public easement of sorts, same as a gas pipe could be a public easement, a utility line can be a public easement, a sewer line can be a public easement, conservation land can be a public easement.
And so there's
The point is that the town does not own the road underneath.
Mhm.
They own the
Except-
easement and they
except-
maintain that easement. So it's a town way only in such that the easement is maintained. They don't own the land underneath those.
They don't, but they also hold the utility rights, and they also hold the right to be able to give permits for location permits for utilities, poles, pipes, all that.
Correct.
It is more than the average public easement. It is more than the statutory public easement. So
Well,
I
the
hear what
public
you're saying.
easement, continues with the utility easement. Even on a discontinued road, those utility easements go
Yes.
along with that public easement. So it's
Those-
only when that goes away that there needs to be a specific utility easement if we're talking about that for that purpose.
And then the question is, where you've got a public easement that the town has a right but not an obligation to maintain. It can go away at any time. Is that a way that's maintained by the town? That's part of the definition of a public way.
Can you repeat that question again? I didn't understand. We're talking about easements and then you just mentioned ways. So can you repeat that again?
Okay, well, where the context is, we're talking about the definition of a public way. And a public way, under the state's highway laws, means a way owned and maintained by the state, a county, or a municipality. So it's owned and maintained. over which the general public has a right to pass. So I'll grant you that there is a whole class of roads where the town way is established as a public easement of passage. Well, we call it a town way. Those have to be maintained by the municipality. Whereas a public easement is just a right by the municipality, not always exercised to maintain that. So is that a public way? I don't know the answer to that question. Is that something we might be, we want to think about? Or maybe it's just hurt our brains and we move on.
Well, if that brings.
How did town roads fit in? I mean, state roads fit into this?
It's a public way. It's owned and maintained by the state.
Well, is it owned or is it like Rebecca's saying it's actually owned by the people underneath and it's just an easement?
Since 1951, the presumption is that the state owns all highways and fee.
So is that all highways and all state roads and all state aid roads, or where's that change?
Yes, all state roads and highways.
He's shaking his head.
Yeah, I'm not the property from DOT, but it was my understanding that most states, highways and state aids, and I'm not talking the interstate, just normal roads across the state that are maintained as state highways or state aids, most of those are easement highways.
They may have been up till 51. Since then, they're presumed to be in fee by statute.
You know which statute?
But a lot
that
of
is?
roads were laid out before 1951.
Again, I'm not the property guy here,
Yep.
but that would be new to me.
Do you know what the statute number is on that, Jim?
Off the top of my head, unfortunately, I don't.
Because I know there's one having to do with town ways being in fee simple after a certain date. But and I can't remember whether that's 3022 or somewhere right in that set of statutes there. And I can't remember what the date is. I was thinking 1959, but I might be wrong on that.
Well, it's interesting what is ownership for purposes of this? Is it fee ownership or is it ownership of the easement for passage? I don't think that anyone's going to dispute that a highway that was laid out as an easement highway by the state is anything other than a public way. And it's a public way. We'd all argue that, so, and probably believe that. So
And,
maybe
you know,
we just
most,
walk past this
anything
one.
that exists today as a state highway or a state aid road originally was town way or a county way. Because the state highway commission didn't exist 120 years ago.
And a lot of the ways that are now town ways or county ways were originally an easement of some sort and commonly used by everybody, and everybody agreed that it could be used, but it wasn't formally anything. Easement by acquiescence, maybe, I don't know. But lots of times there was a road of some sort there. And one proof of that is you look at roads like Young Road in Fayette, where it was laid out as a county way in 1791. And it went from one piece of road to another piece of road and kind of wiggled its way all the way across town. It was laid out at 4 rods wide, but there are stone walls on Young Road at 3 rods wide. So there was something there before it became a county road.
So,
So I think the term owned and is what's creating confusion here. Because if it just said means a way maintained by those people,
Well,
we
then,
wouldn't have any question here.
then
But I
you
think-
get into another question, which is what do they mean by the word maintained? Because there's the definition that says maintaining is, putting maintenance to be passable. And then there's another definition that says that maintain means to allow to exist. So in other words, owned and allowed to exist by the town, the county, or the state. Which doesn't necessarily mean they have to put any maintenance into it. It just means that, yeah, that's a road, we let it be a road.
I think the intent of the definition of public way was a way that is indeed maintained by either the state, a town, or a county.
Maintained meaning kept passable.
So what would happen if one of those entities, none of them was actually maintaining the way? Then it's not.
There would be a public way, there'd just be a way.
So if you have a public easement, not the lay term, but the public easement that's left over after discontinuance or abandonment, or the one that's laid out to get to a public recreation area,
And not
is
maintained by
not
the town
maintained
anymore.
by the town, never was. They've decided, we're not going to maintain this public easement. Is that a public way?
No. No, it's not maintained by the town.
So that's the question I ask. That's probably the only ambiguity I can think of that still remains on this one. But otherwise, we all seem to be okay on that. Maybe we just say that that's a consideration as to whether there's any misunderstanding or any confusion on the law, but otherwise it seems to make sense and seems to be a workable definition.
If you think it's important right now, Jim, I could call the fellows down at the property office and ask them about what you just said. As far as being after a certain date, they're all free.
I don't think the ownership's an issue, really. I mean, just as long as a right to go over the road is owned by the town, whether that, or by the state or by the county, whether that's because they own the fee or they have this easement right to go over it, that probably suffices. The question is, if it's not maintained by the municipality and the public easement, the issue that cropped up in some of the comments made today, in writing, for us to take a look at, refer to this, a public easement. You don't know that it's going to be maintained. There's a right, but not an obligation, and it's up to town meeting, which is an annual event. So that whether a public easement is actually maintained or not is always at the discretion of the municipality's legislative body, and there's never a final determination that it is going to be maintained by the town. So there's an open question as to whether a public easement that we talk about in that narrow term, it is actually maintained by the municipality and therefore is a public way. So that may be something that the legislature might want to look at. But that seems to be the only issue left.
So that does raise the question of, if somebody obstructs a public easement that is not being maintained by the public, are they guilty of obstructing a public way or not?
That's a question, isn't it?
Because I know a lot of cases where that happens.
Do we have some comments that we?
Wouldn't they be just obstructing the public easement? Wouldn't that be a thing?
But is that public easement a public way?
But again, the public would have a right to go there, right, through the easement. So any obstruction you think would be illegal.
And yet, when you call law enforcement and say someone is obstructing this public easement, they don't want to touch it because they don't know whether they have jurisdiction there or not, and that's part of the confusion.
Would it make sense that we say that generally public way seems to be understood, but for this one set of issues with regard to whether a public easement is a public way if it's not being maintained by the town? Is that worth noting in the report? Okay. All right. Otherwise, I think what we've said in number 3, it seems to work. It's just this one issue we bump up against. Okay.
This seems to be a time when I can interject a comment about status. Hello, it's Frank Partridge.
Frank.
Hi. My comment here, I sort of have a background in mapping and in computer programming. And it seems like the underlying issue of everything is the current status of a roadway. No matter what designation, what label you put on it. It's the current status. And so I think something would be helpful would be to build a model, something like a flow chart of status that had the history of each of these transportation networks, roads, everything, and even have the matter of easements in there, have the matter of when it was maintained and by whom, when did it stop being maintained, things like that. Because the status of these transportation segments changes over time. And so a historical status flowchart model might be very helpful.
Thank you.
You're welcome.
And just to let you know, Frank, we had the public comments and I had read out your email that you had sent to me.
Thank you.
All right. And then I think one that also won't be controversial would be 6 public roadway. Again, it's not one of the ones asked by the legislature, but it's an oddball term that only appears under Bicycle and Roller Ski Safety Education Act. And it can just as easily be replaced by public way. So that's our proposal, is to just do away with that, substitute the term public way and be done. That seemed to be a workable solution. So if that continues to be appropriate, then great. That's something else we can check out. That leaves the big issues. And those big issues are private way, private road, and public easement. Where do we want to begin? Question, where do you want to dive in, I think?
So I said I did up my comments on your proposed legislation. I do want me to go through that if you like.
Without reading all of this again, were we leaning in one direction between private road and private way?
Where?
Eliminate one of them and why not?
I think we're going to define what a private road is and replace the term private way with, depending on the context, either private road or public easement.
Okay.
I think that makes sense. So maybe where we want to start is dealing with the private way under 2. And item 2, private way, and then see what we recommend. So I tried to go through the history, and Roberta's gone through the history as well of private ways. I think we might be in rough agreement. I think so.
Kind of, yeah. I think we understand each other at
We
least.
do at least. And so, once upon a time, these private ways were to try to get your crops to market, to try to get cultivated lands to public ways. And you would give them to the town, as opposed to the town buying property. You would give the rights generally to the town would accept it and lay out a way. Over time, those became public rights. So the town treated those as being like public roads. The difference being the town didn't ask for it. Individuals did. And that's
One correction I'd make there, the individuals had asked for it. And the town would say, yes, we will lay that out as a private way, but the landowner has to pay the compensation to the other landowners from whom it's taken. So
Right.
it's not that the landowners are giving it to the town, it's that one landowner needs the access, buys it from the other landowners, and then it becomes a public easement.
So it was the landowner who, yeah, I mean, the landowner was paying to the extent it went on someone else's land. The landowner was paying the damages instead of the town paying the damages. But in the end, you wound up with these ways that the town was maintaining. And so they were known as private ways subject to gates and bars. But then by the 1940s, it was clear that the public had a right of access over these properties. So the legislature cleaned things up in the road law back in 1976. When it did, it said that these private ways were now public easements. And then, and it also allowed the creation of those recreational public easements, specifically in 3022, which had not been there before. So we have these public easements and private ways becoming public easements, but what happens when private way really was meant to mean private road? And so what Roberta had done, what I tried to do, was go through wherever we could find this in Maine state law and say, all right, what did they really mean here when they said private way? Was it what we now call a public easement, or was it a private road? And so that's what we've done, tried to do here in the text and in the proposed changes. Berta, would you like to go through the discussion on this? Or you have comments on specific ones? Would that be?
I don't think I separated it out by
You could-
private way. I went through page by page.
I see.
Well, let's see, where did? Even your, I'm looking at your draft, proposed legislation now.
Right.
And my comments are, section 159E, I think that's a great improvement. The only thing I found there was that in the last line, you had the words materials and fuel in there twice.
Oh. Never trust me, you're type in word problem.
And then on page 2, paragraph 4, where it says failure to guard or warn against a dangerous condition, does that mean that if there's an ice storm and we haven't been out to look at the road and somebody else comes in and skids on the ice and has an accident, are we liable for it because we didn't warn them? Because we've actually had that happen. Fortunately, the person didn't hold us liable, but under this, it sounds like they could.
The first part, it's easy where you dig a pit or something that somebody could fall into, you leave an excavation open or something, leave some kind of dangerous situation. I guess what we're just gonna talk about the issues one by one, then this is sort of out of sequence. It's not a private way issue. But we're here, so let's just go through it because this is we've been asked to look at terms. We also earlier this year were asked to come up with priorities, or we volunteered priorities. This was a big priority.
Well, it says maintenance of a public easement, so.
Yeah. All right. At any rate, the idea was that you don't create a huge hazard and leave it for the next guy to stumble into. And so you need to mark it. If you're aware of a hazard that has been created on your property, even if you didn't create it, you're inviting people over it, then you should be signing it.
Okay, so when there's ice a quarter of a mile from our house on the road that we've been maintaining, because we plowed it and then there was an ice storm, are we going to be liable if somebody skids on that ice when we haven't been out to see that there's ice there?
Is that really a willful or malicious creation of?
No, but it says, failure to warn against a dangerous condition on the public easement.
Mm. And you could be.
How about dangerous condition that is created through the management actions? that you'd have to notify.
Or would they say that because we plowed it and didn't sand it, that was our fault? Nobody would have tried to drive in if we hadn't plowed it. I don't want to spend a whole lot of time thinking about that, but something to maybe put a question mark on that one and think about it, see if we can come up with some wording that would clarify that.
We're taking out that little phrase, or failure to guard or warn against.
What's that?
We're taking out that little phrase about or failure to guard or warn against.
Yeah,
This was taken out of the landowner liability question, issue, so in 159A, we could omit that. What's difficult here is that if you're going to be doing work on the road in order to get to your house, you're an abutting landowner, you're probably not going to be working just on the part that abuts your house. You may be working on the entire road if you're the only person who lives on it, or two people may live on it and they may together take care of that whole road. But if you know that the road is icy because of some current condition, there's been flooding and it froze up afterwards, for example, or something like that.
You just used a word there that might help. How about failure to guard or warn against a known dangerous condition?
But then if somebody calls you and tells you about it and you don't do anything right away and somebody gets hurt, then it's even worse.
Well, it's on you. Failure to guard or warn against a reasonably known dangerous condition on the public easement. It's within reason that you know that it's icy, or it's within reason that you know that it's flooded and nobody should be driving because there's 3 feet of water.
So that would be like the pothole law that if you've had 24 hours notice and haven't done something about it.
Then
So I suppose even if we don't have a sanding truck, we could go out and stick
Sign
a
it.
cone marker on it and
Yep.
say caution ice.
that's
If
what I'm
somebody
thinking.
told us that it was icy,
Right, if it's reasonably known to you.
okay,
Is that a little better?
that's better. Yep.
So what if you're not there?
Then
What
you
if
don't
you're
know.
these landowners, but you are in Florida in the winter? This happens. Do you
They
have a
probably-
responsibility to come and get it addressed?
Yeah, then you're not doing maintenance on it, so you wouldn't be liable.
That's correct. Great. I'm asking.
Okay, we've got to test these things. Let's take that. A failure to guard or warn against a dangerous condition on a public easement, we'll say reasonably known to the landowner. So that if you're in Florida or, you know, it's something that immediately happened 5 minutes ago and you don't even have time to react to put the sign up, you still are okay, or should be okay. Now, that's one issue. Carla, you had raised an issue about this language as well.
We have, I think, we appreciate the putting this forward, but have, as if you've read my comments, you know that we have concerns generally about the report and the proposed legislation. So there are other questions
Right.
and comments we have about this. As well as some of the other language that the terms that are being put forward. But one of the questions that Tom Doak raised, who's my boss, is down in section 7, where it says the court may award any direct legal cost. In the landowner liability, I think the word is shall instead of may. And we're wondering why there was a distinct difference here.
We can change that to shall and see how that applies. Does that sound reasonable, that the court shall award any direct legal costs, including attorney's fees, to an owner, lessee, or occupant of property abutting an easement performing repair or maintenance if they're found not to be liable for injury? So if somebody brings the case and you win, you're found not liable, then you shall get your reasonable attorney's fees. Does that sound reasonable to start from there?
Carla, what section did you say that?
It's in number 7.
Right, but you said that it says shall, where else?
Oh, it's in the general landowner liability and what is it, Title 14?
Yeah, Title 14.
All right.
Yeah, that's in 159A, so yeah, okay.
The other thing I raised in my letter is that the piece that we put forward on environmental damages, we neglected to address the issue of who is responsible. And so we think that that should be addressed in here, and that in the situations where you can show that it's not by substantial credible evidence that the violation was committed by another person, but perhaps can't show who that person was, we believe the liability should lie with the municipality who is the holder of the easement.
I like that.
But the municipality has the right, but not the obligation to maintain, and may not have maintained it.
But if it's
I'm looking for a
environmental
comment from MMA on that proposal.
It's already in the environmental statute.
That it becomes the municipality's issue.
Specific to hazards that deal with waters of the Maine, of the state of Maine.
I think this is broader than water, so.
So if we were to say that the owner of the property is not going to be responsible for remediating or abating the environmental damage, but the municipality will be, that's not going to cause
No,
any harm?
it depends on the facts of the situation. If you have somebody that goes in and dumps a huge amount of oil onto a roadway that is leaking into adjacent wells, that's not the responsibility of the municipality simply because they own the easement. That's a hazardous cleanup that needs to have some state skin in the game.
And if somebody goes there with a logging truck and puts huge ruts in the road that wash out during a significant rainstorm that every once in a while happens, and causes siltation and problems with the receiving waters along the side of this public easement, municipality is going to be willing to cough up the money for that damage?
No, they're not going to be willing to, but there are existing statutes that direct municipality to deal with the runoff, specifically stormwater runoff and environmental damage as a result of that to receiving waters.
I think what's more of an issue is not if a logger does it, because then you would know who did it and they would be responsible, and they, in most cases, would step up and fix it. But it's more of a problem where you have somebody with their souped up 4-wheel drive truck going out mud running. And they come through at 2 o'clock in the morning and nobody has any idea who it is. And they can do a whole lot of damage during mud season.
Okay, so then we should say that the obligation to remediate or abate is the municipalities in these instances?
It's their easement.
Is that the way this, is that what this commission is, accepts? Any opposed?
Obviously, yeah, of course I'm opposed.
Okay. How about if we just leave it open, because we're just saying that the landowner is all right. The landowner is not going to be liable. It leaves DEP to go after whoever is really liable, and that would be whoever caused the problem, dumped the dirt, dug the trench, did something that would cause damage to a receiving water, whether that's a ATV operator, the mud truck, the whomever, or maybe the municipality. it's up to someone to determine. How about we just leave it open?
And what do you do in those instances where you can't determine who it was, who's responsible for, under that situation?
That's why we're here.
Well,
Right.
the person who's entitled to relief is someone who shows substantial credible evidence that it wasn't that person who did it. It was committed by another person. And so in order to avail yourself of the defense, you have to show someone else did it. And that someone else is probably going to be the one on the hook.
But if you can't find them, then
You don't get the liability limitation. You're not off the hook with DEP because you haven't shown reliable evidence, credible evidence that someone else did it.
Wouldn't it be possible to show evidence that someone else did it without actually knowing who the someone else is?
you can prove it wasn't me.
Well,
You
we're
just can't
trying to,
prove who it
we're
was.
trying to protect the landowner here and not necessarily solve DEP's problem for them. That's up to them to try to figure out who did it.
So if you can say, I'm not the one who drove through with a four-wheel drive pickup because I was in Florida, then you proved it wasn't you, but you have no idea who it is.
Well, the idea here is to create a limitation of liability for the landowner who takes care of the
I
road.
think it accomplishes that,
So,
but that doesn't accomplish fixing the environmental damage.
Right.
and isn't that DEP's responsibility to try to abate or remediate the
The
environmental
other
damage?
question I have about that is, I mean, is it like when it comes down, like if there's ruts in the road, is it like, I mean, we could all argue it's environmental damage, but like where is that? Like, I mean, ruts in the road from the springtime that they would grade out, that you could grade out, or like someone drives a 4x4 pickup up there, and DP's like it didn't have any effect on the environment in there, but the person that owns the land there is upset. So environmental impact doesn't completely fix the problem.
At least it's a step in the right direction.
The title of this section is landowner liability for environmental damage by others. And so, we're trying to say that there's limited liability for a landowner who tries to repair the road from third-party damages. I take my Camry down the road, which is probably kind of stupid, and it gets banged up, and you're not on the hook. There's also, we're trying to limit landowner liability for environmental damage by others, where you can prove with substantial credible evidence that the violation was committed by another person. We're trying to get the landowner off the hook.
I think this does that.
As is.
Whose responsibility is it to go after these people that made the damage? And I think you're putting a lot of this on a department to go after these people, and they don't have the resources to go after these people that caused the damage.
So then who should pay for the damage?
It's the person who caused it, you can't catch them.
The town.
Do we need to solve DEP's problem? Maybe DEP will have some ideas if draft legislation gets out there.
Oh, they'll be there.
Why not?
They'll be there.
Or is it the town's problem because the town keeps it as a public easement? And if it weren't a public easement, the private landowners could gate it and keep the four-wheel drives out.
Or is it the private landowner's problem? Because if they weren't a public easement, they wouldn't have any right to get to their houses and they'd be landlocked.
Aren't we just trying to protect the landowner against them being liable? Why do we get hung up beyond that?
Thank you.
Yeah, I agree.
Our point was just that it leaves the question open and you really want to have the environmental damages, remediated or abated. And so answering that question provides that guidance and doesn't leave the question open for further litigation. And
I mean, the department can bring an enforcement action against someone.
What
If they can-
department? The department.
Department of Environmental Protection can bring an enforcement action against someone for violating the environmental laws of the state. Yes, it puts a burden on them to do that, to do the investigation and all that, but they typically do that. That's part of their charge. It is a consensus that we send this forward as is, with the change that, we changed the limitation piece in number 4 to talk about dangerous, failure to guard or warn against dangerous conditions on the public easement reasonably known to the landowner. and shall award in 7, any direct legal costs to the landowner. Is that something we all can agree on, even if it's not our first choice to leave that issue out there?
I think we would object to it.
Okay,
Is that, when you change shall, does that make that paragraph match the recreational liability law then? At that
Yes.
that's proposed, yes.
Because if it does, it would seem as though that would be easily accepted because that law is already on the books elsewhere.
Right. Okay, let me ask a quick question. How does this commission want to proceed? If do we want to go majority minority? If one person objects, we just note and say the majority of us approve this. Do we want it to be unanimous? Do we want it to be by consensus? What happens if one person or 2 people or 3 people object?
Probably I note that down.
How do we all feel about this?
It doesn't provide a unified front when you go in front of a committee. If you have descending and ascending. However,
Oh,
the
sorry.
committee, you're able to voice your strong, your objections, as I know.
I don't think that with our position that we're necessarily gonna be able to get to a consensus. With our position overall on the report and the draft legislation. So I think at least the majority minority option would be wise.
How about a supermajority of some sort? Like
I think the report
2/3
itself
or-
got to be able to have, majority opinion, minority opinion, or consensus. When it comes to putting legislation through, that's when it's going to be a little more tricky, because if we're split on it, probably doesn't have a snowball's chance to even get started.
What I said, right.
Do you guys wanna take a vote on how you wanna do the voting, or?
Are you suggesting unanimous consent on item by item basis rather than unanimous consent on the whole body? I guess it would be the same thing.
Point by point, I think. Because there are probably some points that we can all agree on. We have to at least get those through.
Yeah, well, I think we've gone through 3 points. Definition of way, the definition of public way, and the definition of public roadway, where we're unanimous. I didn't hear any objections. I think we're all okay with that.
I think that we do object to some of those, given our position that it needs more work, and we're concerned about the implications that some of the changes might have. Where the ones that we've gone through were areas where there were no changes, is that right?
With way, there were no changes. With public way, there were no changes. One slight question. And then public roadway, there was a change. I think we all agreed to substitute public way for public roadway wasn't a big deal in the bicycle and rollerblade statute. So I think those 3 areas are pretty safe. Where we started, we knew we would be going down a difficult road, was where we started with private ways. And
Sorry to be the difficult one here.
no, I mean, people have their organizations and their perspectives. And that's why there's so many different people on this committee, and why the different perspectives are represented here. So the question is, when there's a difference of opinion because of different perspectives, does this commission want to say we will only act on those things where we're unanimous? Does this commission want to say we'll only act on things when there's a consensus, which doesn't mean necessarily you get everything, but you can live with things that may not go your way entirely? Or do we want to say that it's a majority minority, or as suggested, a super majority? We have 12 members, and maybe instead of a 7-member majority, we we require a 2/3 of 8 members.
I don't like the idea of the supermajority. I think there can be one or two of us that could be really strong holdout for good reasons. I wouldn't want that to be just not noted.
Well, there would always be the opportunity to put together, I suppose, a minority part to this, and so, and those who are in the minority on that could write that report or could help write that report. Just a thought. Do we want to take 2 or 3 minutes to think about this and reconvene, or is something we want to talk about now and just go around the room?
are we, I mean, so the landowner liability one, like, we're all pretty much, other than the environmental impact, or are they two separate things?
I think we would still object to that,
The
given
liability.
yeah. I mean, we appreciate that it's in there and that we're making some attempt to change it, but I think that
So if it mirrored the landowner liability law, you would be against that.
we think it could more closely mirror the landowner liability law, but that the environmental damage piece is something that we feel strongly should be addressed.
The problem I could see with that is, like, it's just who deals with it. Like, I mean, I know it goes to DEP, but DEP, I mean, I've dealt with this before with dams, people ripping culverts out or dams, and to get DEP to do anything about it, it's an act of Congress. Like, unfortunately, it's just the way it is. Like, and then we end up getting calls about stuff. I mean, we get the calls all the time about the trucks going up through the roads. So that's the damage comes to us because we're the face. And unfortunately, a lot of times, just like you said, we don't know who it is. So it's no way to charge them. An environmental impact, like, we have no laws, like, other than nothing really there. Our best laws are operating a motor vehicle on a snowmobile trail.
Forestry, Chris, they enforce some of that sometimes too. I know we've had issues where we had trucks out there on the trail systems and they were able to catch them in the act, and they can be prosecuted for what, like up to $10,000 worth of damage, I think. So, but it's hard. I mean, we all know trying to actually catch them in the act and prove it is very tricky. I would hate to see us lose the chance to protect the landowners so the landowners aren't liable because we got hung up on trying to figure out who else was liable. That's just my 2 cents.
I think that makes sense. Don't throw the baby out with the bathwater.
And the other thing, I mean, we're probably never going to get us all on the same page on everything, although, maybe we will. It'd be great if we could, but it's likely that we're going to have to go with some level of majority. Somebody early on today mentioned that, they thought they were going to have help, and then their legislator backed right off. And part of the reason for that is the same thing Chris and I are facing right now. And probably, DOT will be in the same boat. I mean, we're getting, comments from above, from our commissioners, that the administration is going to weigh in on anything before we can officially, be publicly supportive. And so we need to keep that in mind because, unfortunately, every time we've ever tried to do anything with these road things, sooner or later, top down, things get slowed down or whatever. So I think the more we can do to keep them clean, crisp, and concise, not maybe try to get everything at once, but let's get what we all agree we should get and see if we can get that through. I think that's time well spent.
Like Roberta brought up a good point in her notes on 7, like, I've kind of talked to our administration about it and like failing to use the right of way for operating a snowmobile and in public ways and stuff. And I mean, I'm gonna be honest with you, like, we're pretty much like, hey, listen, if there's a stop sign, you should be stopping, because I'm thinking about camp roads, like people coming off the lakes and coming up on the, like, or logging roads, for example, like we had 3 fatalities last year, people crossing logging roads. So that's gonna take a bigger picture look as to, like, us looking at it like, okay, we need to back away from this a little bit because public way doesn't even cover that. So someone pulls out in front of a logging truck on a warehouse or like, who's liable? Like, really, it shouldn't be the logging truck's fault. It should be the snowmobiler that blew through the stop sign. But like, when you start really reading this, it's like, there's really no violation. So, and we're in the interest of protecting the people that are on those roads, whether it's a camp road or whether it's a public way. And maybe that's gonna be something that we have to look at further down the line as to, hey, if there's a stop sign, you need to stop your snowmobile. There is no, like, it's entering public way, but there's nothing, and it kind of goes into the last one. I mean, and you brought that up in your notes, Roberta, and that's where I was kind of coming from, like, hey, they should be stopping. There's a stop sign, whether it's a public way, whether it's a camp road, whether it's
Whatever it is.
intersection, yeah. And I know John, I talked to John Monk about it, and Brian's probably on the same page, like we're all, but it could have underlying ramifications in Title 12. But we're a little hesitant on that.
And that's a problem, all of these,
Yeah.
we're dealing with several different statutes and they all interrelate.
One thing that I know, Tom Doak has said to me in the past is we're not going to solve everything at once. We've got to be satisfied with getting some progress. So I think he would probably agree, and maybe you're overstepping my bounds saying that, but I'm just guessing what he might say if he were here. That if we can get this much of the liability fixed, that's progress at least, and maybe next year we can find something else to try to catch the person who's doing it, make them responsible.
I don't, my marching orders were to object,
I
to object
appreciate that.
and,
No, we respect that.
and to take that position and put forward our rationale.
I understand that I get my marching orders too.
So I don't know, if I go back to him, I don't know if, you know, he'll agree, given the changes that were made. So it's hard for me to say. I would need to have another conversation with him.
So a question I have is this: what if the report goes in, you know, if we, let's say, just for round, you know, for sake of discussion, we say supermajority. We'll put in the report what, you know, 2/3 of us all concur should, you know, potentially be looked at, and discuss the other things that came up, just include them in the report, but only actually draft language for legislation if we have consensus. And let the legislature, if they want to draft additional stuff based on the report, they can do so. And then we can all, you know, our departments or whomever can all testify, you know, based on that at that time.
How do you all wish to proceed?
I think if we go into this with mixed ideas on this, and then sending it forward with proposed legislation to people that don't necessarily, I mean, if there's one group of people that knows the most about this, it's the people that are either on this committee or involved or interested in being part of this, and not necessarily people that we elect to make these decisions. I think we should be as united as we can so that we can help them make their decision wisely and not maybe inadvertently make it worse. Because we're trying to make things better here, and if we leave it up to folks that don't necessarily know as much as we do, I'm afraid of what might happen there.
If we go in with majority and a minority report, we may as well give up, because they're gonna look at that and say, well, if you guys can't agree, then we're not going forward. That's state and local. they're gonna see that. Another thing they might do is they're gonna say, we wanna hear from these people that dissented or didn't agree with it. And then that's gonna bog it down some more. It's go and do what you can win at this point in time. We're a lifetime.
We're not on it for lifetimes, but this is a standing
If
committee.
I have a week like I just had, my lifetime is just been made shorter. But
Thank you for showing up.
no, it's
How about an idea where we pretend it's the Olympics and we get to throw out the worst judgment, right? You always got to throw out the 0 from the Russian judge or whatever, you know. So if you'd have like only one dissenter, and otherwise everybody wasn't supportive of it, I would go with it myself.
Here's another thought to throw into the mix. Tell Tom he owes me one. Because I saw
Feel like
some
we're playing
real
poker.
problems with the revision of section 3028 to 3028A. And he said, please, please, please don't object because we've got to get this through. We've got to be all unified or this won't go through. And you know, it's gonna be some improvement. And I said, yeah, it's gonna
That
be
brings me
some
to a
improvement,
question
but it's
that
gonna
I
have problems.
Like about,
But I kept my mouth shut. So now he owes me one. We're
Noted.
gonna improve this liability piece.
the
Tell
one,
him he owes me to let
one
it go
about
through as is,
operating.
and we'll work on the other part later.
the one about operating ATV on a public easement, which, and I was like, it says without the permission of the abutting landowners, and we're talking about minority, majority and everything like that. And I'm like, so if you have one
Yeah.
person out of 10 people on these places, is it the abutting landowners, is it a minority, is it a majority, is it one landowner that blocks everything?
Well, what do you do now? Because ATVs only operate
You only operate where you have permission to be there. So technically,
from everybody or as far as you have.
nope, it has to go. Like, it has to go, as soon as it goes across your land, you have to have permission. So technically, like what, like, so if it's a public easement, you're saying that you own to the center line, I guess, the abutters, so one person could block it. Is the way I understand it. That's correct. If you're saying
I
that
mean, the problem right now is the law says you gotta have landowner permission, but the roads are treated differently because they're considered public. And if they're really not, if Rebecca's right that all of these roads are really easements, and therefore we need all of the abutting landowner, then the towns can't open access roads, the state can't open access roads, and we can't use discontinued roads unless we have 100% of the people on board. But I guarantee you'll get pushback from the state and the towns and everybody else that that's the case. And that's my concern is we're literally going to take a discontinued road, unmaintained road problem and now make it apply to Route 201, Route 2, everything else as well. And it'll just all blow up in our face.
I guess, well, that is my question. I mean, if it's a discontinued road and there's a public easement, right? Does it go to the abutters that go to the center line, even though there's a public easement?
All right, I think this is one we can all agree on. When there's a road that is discontinued, then there is, since 1965, an automatic public easement. It was called a private way till 76. But it is an automatic public easement that's retained by the town in a discontinued road. So where the town meeting gets together and says, we don't want to have to be responsible for this road anymore, for whatever reasons, we're discontinuing it, there's an automatic public easement that's retained. And when that happens, everybody, all the abutters own to the center line, and the town has the right, but not the obligation to maintain it. I agree. We're all in agreement on that piece. And if a road is statutorily abandoned, not abandonment just happens. If it's a statutorily abandoned because a town hasn't spent money for 30 consecutive years to maintain it, it has the same effect as a discontinuance. So we are the Abandoned and Discontinued Roads Commission. When there's a discontinuance or a statutory abandonment, same deal. Abutters own to the center line, town retains an easement unless it says otherwise in the order. And that public easement gives everyone the right to go down, and the abutters own it to the center line. Town can maintain it, doesn't have to. In that instance, it's been this way all along. What has been done with ATVs where you're supposed to get permission of the landowners?
Towns.
So they get to use it. What they're told is based on paragraph D under Title 12, which says an ATV may be operated on a public way, does not maintain or use for the operation of conventional motor vehicles. And that right there is what they use, towns, everybody, to say they can use those roads, and they don't even need anybody else's permission because the law says they have a right to be there.
So go ahead.
That's why originally I said, what if we remove that paragraph? Then that would force them to have landowner permission. But that does create other problems because, in fact, some of these, you know, and we've heard this, that we could have a landowner out there on one of them roads who, that's how they get to their places with ATV. But somebody else who is an abutter landowner says, we don't want ATVs, and so they block it off. So not only would it stop me, general public, to be going out there, but it would stop me as your neighbor, who that's how I get to my land, from going there. That's the problem.
I think this is a time to interject this. I agree with you, Stephen, and with Chris, also on the permissions part. But I think that this would also touch on the liability issue, is that permission to go on the private land should be by contact with the owner and then explaining why going on the land, and that the landlocking issue should be moved up much higher, in that none of these access issues should prevent or should allow landlocking. So if the only way to access that land was through the public easement on an ATV, then that should just be a given. They should just be allowed for that. But the permission to go on the private land is very important, because as a landowner, I've had a few hunters contact me asking if they can go through my locked gate. And I said, well, do you have any maps of ownership? Have you gotten permission from the abutting landowners? Well, no. And so I denied them. And so I think those two issues of preventing landlocking and liability could be addressed by having landowners post contact information about the gates, saying, yes, it is a public road and you can access it, but only for some reasons at certain periods of the year.
The commission actually appreciates your comments, but we're actually not taking public comments after that, so.
We had our
I'm so
public.
sorry. I'm so sorry. I didn't know Stephen was on the board.
No, it's okay. And so I didn't lay out any rules at the beginning either. But if you have comments, if you wouldn't mind just emailing me, and then I will share them with the commission, your thoughts, because we are always interested in people's thoughts. But that way we have so much to get through and we're already like really behind.
Oh, I'm sorry. Yeah,
No,
pardon me.
Okay. You didn't know.
I'll do that.
I just to let you know. Thank you.
Thanks, Heather. Yeah.
You're welcome.
But it is worth pointing out, on ATVs, a person may not operate an ATV on the land of another without the permission of the landowner or lessee. That's the first provision under 13157A. And then when you talk about operating an ATV on a public way, this kind of brings us along to that, what I was raising about an hour ago. Is a public easement a public way? Because here you go, public way. An ATV may be operated on a public way that is not maintained or used for the operation of conventional motor vehicles.
There, that's the key right there. If you have a public easement that is not being used by motor vehicles, I think that's different from a public easement that is being used by motor vehicles. If you have a private landowner who's maintaining it so that he can get to his property with a motor vehicle, I think they should have to ask permission from the person who's doing that maintenance. If it's not being maintained for someone to get to their property with a motor vehicle, then maybe that's where the public easement kicks in.
If a public way includes public easement and the public easement is being maintained by the town, then you go ask the town.
That's what I was saying.
And that's what I was trying to get to in the draft legislation.
The only thing is I look at like the abutting, like,
Yeah,
it's a majority.
well, if it isn't being maintained by the town, then you're going to go talk to Roberta
Mhm.
because she's an abutting landowner. And the question is, if you don't get all the other abutting landowners in, then maybe you can't use it. But wouldn't you be in the same place if in the first place on a private road, no public rights, private road under 1A, you can't operate the ATV on the land of another. If there's a private road, don't you have to get permission for everybody on that road to use that road?
Yes, we do, unless, like me as an individual, let's say I own a camp on the road and I have a deeded easement to my camp. As an example, up by Lake Moxie, the large landowners told us, we don't want ATV use on this road. We, therefore, on the state side, I can't authorize that as an ATV trail. However, several of those camp owners, probably 50% of them have ATVs. They went to the DA and, went to court and said, you can't tell us that we can't use ATVs on this road because we have a deeded easement of access to our camps. And the court said, you're right. And so all of those individuals who live on that road can in fact legally use their ATVs under their deeded right of way to their camps. However, the public at large cannot, and therefore we don't, I don't allow it as an ATV trail. They can't use it as an ATV trail anymore. But the other people with ATVs that don't have rights there can.
Can you by any chance get us a copy of the decision from the DA?
Oh, I don't know. Chris, you may have quicker access to that than I do. Scott Thrasher was in the middle of that, Sergeant Thrasher.
Rebecca, quick question for MMA. And that is there a problem with the idea that if a public easement is maintained by the town, the ATV owner has to get permission from the town? If it's not maintained by the town, it's maintained by the abutters, then you get permission, the ATV owner gets permission from the abutting landowners.
The authority to operate on a public easement is bestowed by the town, not the abutting landowner. So they're the only ones that have the authority under Title 12 to be able to designate it. If you want to, which is what we were trying to get at, create some sort of process that says that either there's a maintenance obligation or a respectable obligation, then we have to put that in statute. Because the statute right now only provides that municipal officials, not the legislative body, can weigh in on that.
I understand. I'm okay. So let me ask it two questions. How does MMA feel about a bifurcation so that who you ask for permission to use the road depends upon who's maintaining it? Do you agree with that piece or not?
I think generally asking doesn't happen if it's maintained.
If it's a public easement, then the municipality gets to make the decision either way, whether or not it's maintaining it. Is that the position?
That's what's in Title 12. Do I think that there should be a process that gets at a lot of the issues associated with that? Yeah, that there should be.
But I thought that where the selectmen have the authority to make the decision, I thought that was for access routes, which are over town ways, not over public easements.
That is correct. That's my understanding as well. And that's the process that's been in place for the last 15 years.
The public easement piece comes into play. It's already in that same statute. All roads are public easements. Not all public easements are maintained roads.
That's where we need to make the distinction then. Yeah, is that
No. Some ways maintained by a town are town ways. They are, if you think of a 3-tiered system, town ways are at the top. They are the roads that a town is legally obligated to maintain safe and convenient for passage by motor vehicle under Title 23, Section 3651. Below that is the public easement, where the town has the right but not the obligation to maintain. They are leftovers after discontinuance of a townway or statutory abandonment or statutory abandonment of a townway. Or
it's the maintenance that determines whether or not it's a townway or not. It's not, but the public easement remains. The public easement is the public easement. The townway is determined by maintenance.
Well, if the town is discontinued, the town can discontinue it without a public easement.
Rarely, but it does, it can. And
Yeah,
it can also, and it can dissolve.
and there's no public easement if it's a common law abandonment of a townway. So that's why most MMA traditionally had looked at it, its legal staff, as being 3 tiers, with the townway being in the top, public easement in the middle, and private road where there are absolutely no public rights and you can't spend public money for public for assistance on that road because it would violate the public purpose doctrine of the state constitution. So I differ and disagree with the concept of all town roads being a public easement. Some may rest upon the idea of a public easement of passage in a more lay sense, as stated by the state Supreme Court, but that does not mean that they are public easements as statutorily defined.
In public access, ATV access routes and snowmobile access routes are in that section. They can only be established on roads that are in fact maintained by either the town or the state or the county as public, whatever you want to call them, but public roads, maintained for the public to operate regular motor vehicles. If they're not being maintained for the public to operate regular motor vehicles, they can't be access routes. This doesn't even apply.
Right.
Except for the status under section D.
Well, section
How many of those have
Section D is not access routes. Section H is access routes.
I think
That's my point. The A, B, C, D, E, F, and G do not apply to access routes. H applies to access routes. So D, D is a completely different animal from a standpoint. It doesn't. Access routes come into play legally on a road that's maintained for the regular motor vehicles. You can't take an ATV or a snowmobile more than 1,500 feet on that road legally, unless it's designated as an access route. But that's, those are down in past D. I mean, it's different. That's why I've said, the discontinued roads, we can actually legally put trail money into. But we can't legally put trail money into roads that are maintained by, town, county, or state as open and maintained for regular motor vehicles. We're not allowed to.
It's that maintenance piece. But the only way that the easement can get turned over is through that municipal action. So the easement, the public easement still exists on those unmaintained roads. So you can go get a butters agreement on all of those and create that access, but that public easement needs to then be designated by those municipal officials as that access trail, or else it can't happen because they're the ones that own the actual easement authority and they have to designate that road.
Well, I hear you, but so I think the issue is you're calling it access trail. I mean, access road is not a trail. A trail is not an access road. And those two have to be separated out. So yes, maybe the town has authority and or requirement to build on that access for use of a discontinued road, but that's not an access route. That's a different scenario altogether. And if they combine the two together, then it doesn't work anyway, because now the town or the state, whoever, has to actually officially designate, sign, and maintain the signs of an ATV access route or a snowmobile access route, which means they're back to doing maintenance. So that's where on a discontinued road, the snowmobile and ATV clubs can actually legally put money into them. They can replace the bridges that are washed out. They can help put gravel, grading, signage, all of that. If it is in fact a public road maintained by the town, they can't do anything.
All right.
Correct. But it's the easement piece.
Snowmobile usage is an important part of the usage of Maine's roads, but it's not the total reason why we're here. And, you know, we've got some issues here. I think we're not talking about designation of access routes. What we're talking about is just the basic ability to operate an ATV on a public way. We agree that anywhere else, you gotta go ask for the landowner's permission. If you're going to operate on an ATV on a public way, you have to follow the provisions in 13-157A sub 6. And you can operate on a public way only if it's necessary, but not to exceed 500 yards to the extreme right in order to cross. You can operate on any portion of public way when it's been closed for winter maintenance. So public way here is clearly town way, not a public easement. Indeed, it may be operated on a public way that's not maintained or used for the operation of conventional motor vehicles. Does that mean it's closed to winter maintenance, or does it mean that it's a public easement that's not being maintained or used?
Or does it mean that it's a road where the town is neglecting its duty under section 3651?
And might wind up with a statutory abandonment as a result after 30 years. Do we need to put this aside on snowmobiles?
Well, I think snowmobiles and ATVs both on, I mean, from what I'm hearing anyway, from the administration, I mean, that proposed legislation as written will be likely opposed, and I've heard from ATV Maine and MSA the same way. So if we're trying to win with something that we don't want to all blow up in our face, I think we set it aside until we somehow can all get on the same page.
Okay. Are we all in agreement? Anyone who wants to proceed in the face of this? Okay, let's set aside ATVs and snowmobiles.
And if you don't mind me just interjecting, and the big part of it too is the conflicting restrictions on ATV on easements, depending on how they were formed, right? So that is like, and again, I had posed at an earlier meeting, why not just give them blanket permission rather than blanket opposition? And then it was mentioned that the ATV law itself could take care of that, any potential issues there. It could clarify any potential issues. So anyway, I understand why move along though.
The question that we always run into is who actually owns it, and that's the problem, is you just never know.
Yeah, who do you ask for permission?
Right.
All right. We left hanging limited liability for repairs and maintenance of the public easement. I think we've kind of gotten close, but then the big issue is, do we only want to act by unanimity? Do we want to act by consensus, which means that no one can say, I object? Or do we want to do a majority minority thing? I'm going to suggest it's 3:15, we've been talking since 1:30. Let's take a 10-minute break and let's come back. And when we come back, let's vote upon how we want to proceed. In terms of overall, do we want to be by unanimous agreement only? By consensus, where I don't like it, but I can live with it, and reach a rough agreement? Or are we going to do majority minority, and if so, super majority, whatever? Think about it, and we'll go individually and talk and take a vote. Does that make sense? Okay, 10 minutes. please.
You have a consensus, I mean, you have a list of what we all agree on, correct?
I'm working on it.
Okay. That would be what probably will pass,
Right.
is what
I
we
was- I
can
was gonna
agree on.
suggest make a separate report, one for things we all agree on,
Yeah.
and one for things we're still working on.
Mhm.
Yeah, we're here forever, so we can.
Results next meeting. Okay.
I don't know that we can agree on anything, is,
Everything we
what I've
can.
tried to articulate, and,
We can't agree on everything.
well, I'm saying Maine woodland owners, I don't know that we can agree to anything. I think our objection is that the report seems, to move forward prematurely before things have been thoroughly discussed and agreed upon, and so,
So,
I'm not sure that I can,
so discussed and agreed upon by who?
by this group and others.
A lot of folks here are representatives of groups or work for state government agencies and have to go back and get.
Yeah.
You get the consent of the folks that they report to. And I get that. On the other hand, we've been asked to do something where we make a recommendation to the legislature as a commission. And, you know, if we're at a point where we can't make a recommendation on anything in this because we have to take it back, I don't know where we are because we have to submit a written report in 2 weeks. So at that point,
We need to find a few more things to agree on.
I think we could submit a report. If we all agree that we don't have to be unanimous, let's just say. We could submit a report on the things that the majority agree on and even list the things that, less than the majority still felt strongly about, leave out anything that we all think is just problematic. And then it doesn't put any of us in a bind because we haven't had to officially sign on and get in trouble with the administration because we agreed to something before they gave us permission to, and still allows you to get a report turned in.
Does the report necessarily have to propose legislation to be done now, or can it just report what we're working on?
Well, according to what Jim had here, it said the commission shall review the following terms, which he already mentioned, and shall determine whether changes to current law would improve understanding and use
Yes.
of these terms to the statute.
Yes,
So,
and by January 5, 2024, the commission shall submit a report to the Joint Standing Committee on State and Local Government with the results of this study along with recommended legislation.
so that's the sticker there is.
It's asking for our recommendations and our recommended legislation.
but if we don't have recommendations yet, simply say that.
We don't have, so do we have anything that we want to recommend to the legislature?
Well, yeah, I think you've done a lot of good work. I've tried to keep up with it, maybe interject a few things. I think a lot's been accomplished right now. Like was mentioned earlier, don't throw the baby out with the bathwater. I mean, I think there's going to be a lot of improvements by what has been suggested here. One thing for sure though is if we've got one of our members that automatically is going to vote it against whatever we come up with, then obviously either we get nothing done or we don't require unanimous consent. And I'd say we do move forward best as we can. If you want to even represent to when we go to submit this and propose legislation, you can mention how many total board members, how many voted in favor of it, if there was any dissenters, and what the dissenters' argument was, if you even want to do that. So they can be the judge for themselves. But we got to keep moving here. I mean, all of us have made a commitment, all of us spent a lot of time, and we got to put something out just per our charge. Thank you.
Carla, does Tom actually object to the things that we had said we seem to agree on, the definition of public way, the definition of way? Are there objections to those as
I
well?
think there are objections to those, based on, concerns that there might be unintended consequences for changes to some of the definitions.
Well, I think some of them were saying they're fine as they are, keep them.
I would need to check on those, whether I have authority to agree to those or not.
I can agree to that. I mean, that's, I mean, like, we don't want unintended consequences by any means out of this, like, I mean, that's probably why we're here from the get-go. So that does complicate things a little bit, but.
Change is always good.
Can't the report cover stuff that we don't all necessarily agree with? Or maybe we agree with, but the, powers to be won't let us agree with. But at the same time, so it would cover more of what we've covered and discussed. So the legislature gets to see that. And then proposed legislation could be much narrower. And just say, we're not willing to propose legislation on these other things yet because there's still too much discussion that had not been, completely finished or whatever. But that way you could still go forward. I mean, I think, maybe I'm dreaming, but that we can get agreement on some level of a proposal to limit the liability of these, what do you call them, abutters or actual landowners, or what, the landowners in and around these discontinued roads should have the same level of protection that regular landowners do under the recreational liability law. And if it can't be done under the recreational liability law, then tweaking this like we're trying so that it gives them the same level of coverage. I think we all agree with that concept. The devil's in the details, of course, but so if we can at least put forward those kind of things and then discuss, or put in the report the other stuff that was discussed and the pros and cons, maybe not necessarily even get into, which group was where, just that in general there was these differing opinions out there, so that the legislature can at least have be informed as to the ongoing discussion.
I agree with Brian because some of the changes that Maine woodland owners are proposing would require a fiscal note and would require the legislature to say, yes, your neighbors are going to be responsible for damage if nobody else is. And they may choose to create a public fund which can be drawn down for that environmental damage. So either way, there's a process that is beyond the scope of what we can be recommending because it requires some process that's constitutionally required.
Backing away from the limitation on liability for a minute, the question I had, and that we started talking about at the beginning of this, coming back from the break, was this. How does this board want to proceed? How does this commission want to proceed? You want to proceed by majority vote? You want to proceed by supermajority vote? It's really up to us to define how we want to proceed here.
Jim?
Yes.
In the statute that created us, there is reference to adopting bylaws, and I know that's not what you're asking, but the statute does say that if we were to adopt bylaws, it would be by majority. So to me, that's what we follow for the process of recommendations in the report. That's my opinion.
Mm-hmm. And we didn't do that right off because we got right into the substance of what we were appointed to do, and I appreciate that. But yeah, how do people feel about that?
The only I would promote supermajority only because we're trying to propose legislation. We're trying to advise this legislature. So we don't want to be suggesting everything if we don't have a very clear, strong majority, in my opinion. I do understand Ryan's point, and that's a fair one, but I think we have to have a really strong support for anything that we're gonna be proposing.
If we were to adopt bylaws, we might say in our bylaws that we would act on proposals by supermajority, we could do that. For today, just so that we can figure out where we're moving from here. How do we propose to proceed? Someone want to make a motion? Or do we want to talk about it, go around the room?
What's Kathy to do?
Why you want to know, Bri?
Well, you've been on the legislative committee. What are they gonna, how are we gonna effectively make change? If we go in with just majority, is it going anywhere? Do we have to be consensus? Can we do super majority? What are they gonna notice?
They'll notice the majority versus the minority. They'll notice that we can agree on a lot of things, but we can't agree on everything. They're gonna notice the people that are descending, and they're gonna want to talk to them. They're not gonna want to talk to us as much, because Jim's gonna make a report, and that'll be the report of the majority, I believe. Is that how that's gonna work?
That's what I would try to do.
That's what you would try to do. And so then they're gonna say, well, why did you disagree with that? And that's where we're gonna have a long meeting in front of the state and local. And granted, Brian, it's been a while since I've been on there, so I do not know these people. They do not know the issue that we're working on. This is all a new bunch of people. And if it's not, then I have to bring Candy in, because someone's gonna know that. So that being said, I truly believe this is all a new bunch of people. So whatever we bring in, they will listen. But they will see that two sides, and there's gotta be two sides. There's always gonna be two sides.
And isn't it also an opportunity, like, for example, on the environmental liability aspect, that if that's something hanging some entity up, for example, that they might, from their group, they might be able to propose something that would be able to take care of that legislatively or otherwise. So it'd just be an opportunity that if something's hanging them up, but there's a potential fix, that they could at least, in a perfect world, they could propose what the fix might be.
You would hope between the public hearing and the work session that they would come up with some really good questions, and that the work session would go smooth. You would hope that. They're pretty smart people, the people that are on state and local. So they'll ask questions, and if they don't, then we have a problem.
Now, when you say they're new people, is that new since they gave us this assignment, or the people that gave us this assignment?
This will be the same people that were on there when we first got charged with
Senator
this.
Nangle, Senator Nangle was the Senate chair. And
that's not someone I'm familiar with. So they've had 1 year under their belt anyways, and I just don't know.
All right,
It's hard to predict them.
I prefer to have someone else make a motion, but I'll make a motion. I move that this commission act on the proposals by majority vote, and I'll write a majority report, and those who dissent on any given question will be free to explain what the reason is for the dissent, and that will be included in the report.
I'll
That's my
second
motion.
that.
Is there a second?
Yes, I'll second that.
So majority means how many?
Well, there are 12 of us, so a majority of the total number of commissioners would mean 7. That's my intent in making that motion. Does that change the second?
No.
Okay. Let's do a roll call vote because we are having a hybrid meeting.
Carla,
Yes.
Brian,
Yes.
Peter,
Yes.
Rebecca,
Yes.
James,
Yes.
Chris,
Yes.
Roberta.
I don't know, I think I prefer a supermajority.
So no.
Yeah.
Vivian,
Yes.
John is out. Catherine,
Yes.
Brian,
Yes.
Steve,
Yes.
Carries.
Okay. We had gone through a few items. Let's take a motion on them to make sure then that we've done that piece. We had talked about public way as in one. Way. Do we approve the text? It involves no changes. Do we approve the text of the report regarding way?
Do a roll call again?
You have to do roll call.
Motion to approve the discussion of way in the report. Under, that's Roman numeral 3, letter A, number 1. The definition for the term of way, and that we don't find any confusion with regard to that, and propose no changes. I move that we approve that.
Second it.
Carla,
No.
Brian,
So you're talking way, just way, not the private way.
Just
This
way.
way.
Yes.
Peter,
Yes.
Rebecca,
Yes.
James,
Yes.
Chris,
Yes.
Roberta,
Yes.
Vivian.
Yes.
John is out. Catherine,
Yes.
Brian,
Yes.
Steve,
Yes.
Carries.
Moving to number 3 that we had discussed next, public way. There's a definition of the term public way, and there's a discussion, number 3. Again, this is Roman numeral 3A3. There's a discussion of public way, and generally we found in this discussion, as we found in our discussions here, that it wasn't really a big source of confusion. The only confusion that might arise is with regard to whether this term includes public easements. Sometimes it does seem to, and sometimes it doesn't. So that's the only potential confusion. Do we all agree with this discussion? And do we agree to adopt it? I move that we do.
Does that mean that we tell them that the only point of contention is whether or not it includes public easements, or are we telling them that we agree with leaving it as is?
We agree with leaving it as is for now, but we do have this concern that it may or may not include.
So that will be
public
noted.
easements. It's something that we might want to consider further, but otherwise it doesn't seem to be an issue.
Okay. So that'll be noted in the report.
That'll be noted as it is
Okay.
here a little bit, maybe a little,
This is just for the definition of public way,
just for the definition of public way and its use in Maine statutes,
completely in all Maine statutes.
all Maine statutes. That it would include Title 25, Title 29A. It's defined in 29A, roads and highways. And then that gets picked up in the ATV and snowmobile statutes.
But what your motion is that we're saying that it is, the way it is, that we're not recommending a change other than you are going to acknowledge that there is discussion with regards to, is it a public easement?
Whether it includes public easements, that's correct. We're not proposing any changes. We're saying keep it as is.
Yeah.
Recognize there's a potential, issue out there, and that's it. So I move that we adopt it. Second. Okay. Roll call, please.
Carla,
No.
Brian,
Yes.
Peter,
Yes.
Rebecca,
Yes.
James,
Yes.
Chris,
Yes.
Roberta,
Yes.
Vivian,
Yes.
John is out, Catherine,
Yes.
Ryan,
Yes.
Steve,
Yes.
motion carries.
All right. 6, public roadway. This is the, again, public roadway shows up only in one place that we were able to find under main law, and that's bicycle and roller skis. We can replace that term with the term public way and get to the same place without having to have a new term that could confuse people. So the motion would be to accept this text and to accept the change to repeal public roadway definition and replace public roadway with public way where it appears in that one statute. I'll make that motion.
Second.
Roll call, Carla,
No.
Brian,
Yes.
Peter,
Yes.
Rebecca,
Yes.
James,
Yes.
Chris,
Yes.
Roberta,
Yes.
Vivian,
Yes.
John Monk is out, Catherine,
Yes.
Ryan,
Yes.
Steve,
Yes.
motion carries.
We'd started with the discussion of private ways, which would be under 2 in this discussion, D2. And we then took a little side trip down to talk about the limitation of liability, which again was something that we talked about as a priority back at the beginning of the year when we identified priorities for future. So it's maybe not what the legislature asked for us this time, but it is a priority identified by this commission. We want to take a vote on the discussion of private, of this limitation on liability, which is toward the back. When we talk about priorities under B, toward the back of this draft report, there's a limitation on landowner liability discussion, explaining that it's a priority and that it's something that you're trying to do here. And then we have a draft, and there have been some changes suggested by commissioners to try to improve it, which would include the shall with regard to insurance, not paying damages instead of may, and included also the idea of putting limitations on that failure to guard against. They have to be conditions, dangerous conditions that are reasonably known to the landowner. Is there a motion to accept that discussion and this legislative change with those amendments?
Can I ask a question?
Yes, please. Well, why don't we get the motion on the floor and then we'll have discussion.
All right.
Is there a
So
second for discussion purposes?
Second.
Okay. Yes, go ahead with the comment now.
Well, what I'm questioning, the way I saw the draft legislation, it looked like it was addressing public easement, not private way. Am I reading this wrong?
You're absolutely right. It is addressing public easements. We started talking about private ways and we went down this road. So now that we're here and we've discussed it for an hour, maybe we should just figure out what we want to do with it.
I mean, because the landowner liability draft that you had, will that apply if this went through and was adopted? Is it going to apply to private way or public easement or both?
It's going to apply to public easements. Those
So how does
public,
private way come into play in that? When we were just talking, we haven't actually been talking about that language applying to private way, have we?
not really, no. We did discuss this as a priority. We wound up spending a fair amount of time on this. I think it would be a good idea to fish or cut bait on this. And, if you don't want to move forward with it, I understand. We'll put it aside in the parking lot and we'll have other meetings to talk about it. But there's a motion and a second. Is there any further discussion on it? Okay, then let's do a roll call vote, please.
Carla,
No.
Brian,
No.
Peter,
No,
Rebecca,
Abstain.
Jim,
Yes.
Chris,
No.
Roberta,
Yes.
Vivian,
Yes.
John Monk is out, Catherine,
No,
Ryan,
Yes.
Steve,
Yes.
does not carry.
What was the vote, just so we,
It's 5 to 1, 2, 3, 4. It's 5 to 5 and one absent, one person abstained.
okay, it takes 7 votes as a majority to move something on, so, we will put this in the parking lot, so to speak, and, we can continue to work on this as we go along. Okay? Thank you. When we're we started off talking about private way, and private way is confusing to a lot of folks because it may sound on its surface like it means a private road, something where there are private rights and there's no public rights. But we've talked about how we got there, and there are public rights in a private way as defined by Maine law. So when you look through Maine statutes, there are examples of statutes where you look at it and say, no, they meant private road, but it says private way. And Roberta had looked at that, I've looked at that, others have looked at that to see if we can try to separate it. Probably the most confusing and egregious area where that happens is with regard to road associations. It's on page 5 of the draft legislation. And there was an attempt to try to clean that up years ago. Once upon a time, before 2005 or so, it used to just say private ways. And when you look at 3101 through 3104, what it really means when it says private way is private road. It was that people who lived on a private road could form road associations. And if 4 or more people, landowners, got together, they could form their own road association and allow and provide for the maintenance and repair of that private road. That was all under this subchapter heading that said private ways. But then you turn to 3105. And 3105 talked about use of public equipment on town equipment on a private way. What municipal attorneys have used that for is for the basis for doing work on a public easement. So my perspective on this is that 3105A and 3106 apply to public easements, and 3101 through 3104 apply to private roads. The amendment to add private roads while still maintaining private ways to subchapter 2 is kind of unfortunate in the sense of it mixed things up. There may be times where there's a public easement. We'll use Roberta's as an example, not to pick on her, but just as as an example where it's a public easement. The town has decided it will not maintain it. The private landowners are maintaining it. They may want to do that themselves. Roberta may want to take care of the entire road. She may agree with her neighbors voluntarily to some kind of cost sharing arrangement. Or maybe they want to form a road association. So maybe this road association should be available to people who live on a public easement where the town isn't maintaining it, as an option. And so that's how I drafted this proposal, so that it's clear that 3101 through 3104 are available for a private road or for people who live on a public easement where the town is not maintaining or repairing that public easement. And 3105A and 3106 apply to legitimize what municipalities do with regard to repair of a public easement. The town meeting, the legislative body, the council can decide whether to maintain the public easement and to what level. So that's what I've proposed here. I'm not trying to dominate the argument here, but that's the basis for it, and that's how we wound up here. And I think this is what causes an awful lot of confusion in Maine law. So this is something that I've proposed we try to take care of, this Title 23, subchapter 22. 23, subchapter 2.
There's a lot that I agree with you on here, and some that I don't. I agree that the heading on the subchapter should say private roads and public easements, not private roads and private ways, because first thing it defines, as it is now, it defines private way as being a public easement. So why not just say public easement to begin with? So I agree with that. I also agree that in the 3105A and 3106, what they intend is specifically public easements, because you can't spend public funds on roads that are not public. So I think that's pretty clear. What I have a problem with, one minor problem is that where you say public easement not repaired or maintained by the municipality, and then we run into the problem in Wyndham and other towns where they plow the road in the winter. Is that going to count as maintenance? Should it maybe say not maintained year round by the municipality? And in which case, does that mean you have to change that in every place where it is all the way through, or can you put in one definition that says that's what it means and then just use the term referring to that definition the rest of the way through? But then my biggest objection is, as I've said before, is it constitutional to use a statute that requires people at the threat of having a notice of claim filed against them if they don't pay, requires them to use their private funds to maintain a public road, which is open to unfettered public use? And I think this might be a good opportunity to ask the legislature to request an opinion of the justices of the Maine Supreme Court on whether it's constitutional to require private landowners to use their private funds, aside from their taxes, over and above their taxes, to maintain a public road for the use of the public.
Well, I don't have black robes, so I didn't feel comfortable issuing any kind of opinion on that issue.
But can we ask the
can't.
legislature to ask that? I know the legislature does have authority to ask for an opinion of the justices because they've done it before. They did it when it came to trying to revise 3105 to say that towns could maintain private roads. And they gave an opinion saying, no, they can't. They can't spend public funds to maintain private roads. So here we have the opposite. We're spending private funds to maintain public roads, which is unconstitutional.
Well, I guess I would leave it at this, or I would put it this way. This provides an option for people if they want to form a road association, and then they can force people to pay. They don't have to do that.
But it's not an option for the people that are being forced to pay. That's why I say if you want to have a voluntary association, then yeah, maybe you can do that because people can say, yeah, I'm going to opt out of that. It's voluntary and my volition is I don't want to contribute to it. But when you're saying you have to pay, and if you don't pay, we're going to put a lien on your property, I don't think you can do that.
What do you mean you can't do? We do it right now.
And I don't think it's constitutional to do that. There aren't very many roads that have tried this. I do know North Road in Bridgeton, they tried it. They ran into objections from the landowners because there were loggers using the same road. And it used to be a through road. It still shows up on maps as a through road. And they had people coming through, trying to get through in mud season and finding out it doesn't really go all the way through anymore. And they'd get mired and damage the road. And the landowners who were being forced to pay to the road association objected to having to repair that damage. So that's where I say it, where there is a public easement, I don't think you can force the landowners to be members of a road association and have to pay to maintain a road that is being damaged by public use.
Is that your opinion, Roberta, or is that law of the land now? Because to me, the law right now says that you can do that. And it might be, in your opinion, unconstitutional, but that would have to be heard by a court and determined.
Which is exactly why I say we need to ask the court. I ask the state and local government to approach the Maine Supreme Court and ask for an opinion of the justices on whether that abides by the Constitution or not. Because the Constitution is the reigning law over the other laws. And if we have laws that are conflicting with the Constitution, then something needs to be done about that.
Is that really our role?
Right.
I mean, it seems to me like this isn't our role.
Our role was to address the problems with abandoned and discontinued roads, and this is one of the problems with discontinued roads that remain public easements.
So I make a motion, we send it all to court, and then we don't have to make any recommendations at all.
Another country.
I'll
very
second
close.
that motion, because that would be status quo.
How do others feel? I've spoken too much on this.
It's not unreasonable to ask the justices to weigh in. They do that, and they have done that. And if that means you wait a little longer, but you get an answer. It's not a big, that's not a big ask. That's what they're there for.
So it comes back that they do have to pay. What's gonna happen?
Take it back to the drawing.
Couldn't we just make the recommendation and put a big footnote saying, by the way, it's been raised, there might be a constitutional problem here. And we'd appreciate your advice on it as we go forward with it.
Okay.
Yeah, I think because of the issues that we're trying to resolve here, they're not at our level, they're at a higher level.
Mhm.
And I think it's appropriate for us to actually recommend or suggest that this be resolved at that higher level to help us out.
Yeah.
Because we're kind of stuck otherwise.
We're stuck on that at one point.
Yeah.
Other than that, we are moving ahead.
But Kathy, how long would that, I mean, if we were to actually do that in a month, is that, and they agree to do that?
They agree to look it over.
Yeah, they agree to put a request out for a review and some sort of answer. Is that something that's gonna take days, weeks, months, or years for them to actually take it up and then talk about it and then come up with a decision? Do you have any idea on that?
You don't know.
The legislation, the law court would try to give the legislature back an answer during the session in which
Yeah.
it's proposed. They wouldn't want to leave them hanging, so it's more a matter of months.
All right.
But it's a short session, so that's going to be a little bit tougher. But generally, we're talking about months, not years.
Okay,
I could
that's
live with that.
reasonable.
The alternative is that we could keep arguing over it for the next 6 years, 12
Right.
years.
I think there's some other issues on here that.
Maybe you have 6 years or 12 years. I'm not
I
sure I
don't
do.
So we want a motion to approve these changes to subchapter 2 of Title 23. That would be the ones at pages 5 through 11 of the draft legislation.
I'll make that movement.
I would agree, subject to those two things. One, considering whether, how this is affected by public easements that are maintained part of the year by the public. And two, asking for an opinion of the justices on whether it's constitutional.
I think the suggestion was that we approve it with a a footnote, or maybe more than a footnote, but it's something that at least one member of this commission has raised concerns about the constitutionality of forcing a person to contribute to a road association to maintain a public easement.
Yeah.
Is that fair?
Mhm.
Okay. So, it's a motion. Is there a second on that?
Second.
Any further discussion?
So Jim, just to summarize here, so in this whole section from page 5 to page 8, or 9, I guess. We're talking about eliminating the term private way and keeping private road, adding public easement. That is specifically not repaired or maintained by the town.
And Roberta adds the gloss, not maintained by or repaired by the municipality year round.
Yeah, okay.
So if they put a load of gravel in, that's not enough. If they just plow it, it's not year round maintenance. They plow and grade, then that would seem to be year round maintenance. Fair?
I'm just trying to think. I hadn't thought of the idea of putting in gravel.
I could go and mention
No, I was thinking specifically of the towns that use 3105A to plow a road. But I'm just wondering how that's going to affect it. If they do put in a load of gravel, is that kind of, this doesn't apply?
Any other comments?
So Roberta, you still thinking about that? Looks like it. So Jim, let me ask another question.
Go ahead.
So when you're talking 3105A, knowing that this is apparently the intent to apply to public easements, there is no ability now for a town meeting vote to authorize highway equipment on strictly a private road, which might be for the benefit of fire and police protection or protecting the lake nearby.
Yeah.
That's what the opinion of the justices said, was that you can't do it if it's a private road.
Right, but that was in 1989, and then this law here, if I remember right, was passed somewhere after that.
3105 had been on the books for a long time.
Right.
And when they changed it to 3105A, they made only very small changes in it. It's essentially the same thing. I think they may have changed one of the terms in it, and that's about it.
So it was 3106. I actually remember that because DEP was for that, and it was to protect, roads that were eroding down into a great pond.
Right.
So does 3106 apply to a town meeting vote required to protect a private road that's eroding into a pond?
Well, a municipality may appropriate, and it would be the town's legislative body that has the power of appropriation. That would be the town meeting or the council.
So in that case, they could kind of overrule for that specific situation, the Maine Supreme Court decision in 89.
The legislature has said that they can do this here.
Okay,
But they're not just generally repairing a private road and spending public monies for a private purpose. They're doing that to protect the public waters.
correct.
That's the difference.
Yep.
Nobody's challenged this, but that would be the distinction, I think, that the legislature would raise.
All right.
Now, there's always what MMA Legal had said back in the day, was there's always the ability to run a plow in front of the fire truck to go down a private road in order to prevent someone's house that's burning or property. That, you do what you have to do as a sort of gloss on the public purpose doctrine. You're not going to stand there and say, I'm sorry, we didn't want that house burn. You can do what you need to do in an emergency to get there for help. But that's not under this statute. This statute was always interpreted by legal staff and by municipal attorneys to be the authority of the town meeting to authorize some level of repair and maintenance in public easement.
Okay,
You're talking about 3105A,
31, what's now 3105A.
which is why we end up with arguments where some towns are saying that it only applies to, as you said, running the plow truck in front of the ambulance or the fire truck. But if they're already allowed to do that, then there'd be no point in having this law to say they can do it. So
Well,
this
when I
law
say-
should
yeah.
be for maintaining a fire lane in case there's a fire.
Well, 3105A is meant, I believe, and many of my colleagues agree, was intended to allow towns to maintain public easements if they wanted to, if they voted.
Yeah.
Legislative body would vote. The fire, the plowing in front of the fire truck for the emergency was just a sort of it's nowhere in state law, but you do what you have to do in order to protect the public health, safety, and welfare in an emergency situation. And we'll let the justices rule on it later, I suppose.
so Jim, what you're saying is you and your colleagues agree that that really applies to public easements
Yes,
and does not apply to private roads.
correct. Correct. So when private way is used there, it should be read public easement,
Okay,
not private road. Whereas in the other provisions where it says private way, it should be read private road. That's 3101 to 3102.
all right.
So then when you have a town that votes to authorize their selectmen to use equipment when it's a matter of fire and police protection, and the road is getting encroached with snow towards the end of winter, and there's not room for a fire truck to get down it, and you call the town and they say, sorry, we'll only bring in the plow truck when the house is on fire.
That's the reason why, what I just told you. It's not a public, if it's not a public
It is,
easement, they've
but it
voted,
is a public easement.
but they haven't voted to maintain it.
Yes, they voted to authorize the selectmen to do it when it's a matter of fire and police protection.
That's going to be something for those folks to work out.
But doesn't this law say that that's what it's supposed to apply to? Is to keep that fire lane open?
I think you're getting to the practicality issue there, Roberta, because yes, they voted to approve that, plowing down and kept it reasonably open. And yeah, it snowed and it got narrower and narrower. And the chances of a fire are probably remote in most years. But I don't think they wanted it to go as far as saying, we're gonna treat this like any other road that might have a house fire, so we're gonna plow it all season.
No, that wasn't what was asked. What was asked was, can you bring in your wing plow and wing it back once? One pass in, one pass out. That's all we're asking for.
It's going to be at their discretion.
Yeah. There's all kinds of practical things you can come up with here, like,
Because they're
are the
accused.
plow guys really gonna get out of bed before the fire truck guys? I doubt it.
And their excuse was that, oh, this only applies when the house is actually on fire.
I have heard that said.
Which they'll bring the grader in and make a hole.
Any further discussion on the issue here, whether to adopt these changes with the changes we talked about?
So how many pages of this are we actually talking about adopting?
Again, pages 5 through 11. We're talking about section 9.
Right, so the snowmobile stuff on page 13, you're not including, correct?
Touching it. I don't think we have to take a vote to know that the snowmobile stuff is not going forward right now.
No, I think the stopping before entering a public way is pretty uncontroversial, I would think. And
Well, the
kneeling
public way is already in law. It's the public easement that's in question, because if everything's a public easement, you're talking about a snowmobile being liable for not stopping on a trail that they're maintaining.
No, this only applies when they're entering a public way or a public easement maintained for travel.
Yeah, but what kind of travel? If it's the town of the city of Caribou maintaining the discontinued road with the groomer for snowmobile travel, that's an actual that goes on right now. Well, how's that apply to that? That's the issue. This just creates a whole nother set of issues for like Chris and company trying to enforce, and the town trying to figure out what they have to do.
So because the snowmobile part is not what we had motion on
Right.
here, can we vote on what we had a
Right.
motion on?
Right,
And then maybe
go to
come back
that.
to the snowmobile if we so
Yeah.
desire?
Yes.
5 to 11.
5 to 11.
Pages 5 to 11, section 9. There's I've made a motion. There's been a second by Catherine, and you want to call the roll? Are we ready?
Carla,
No,
Brian,
Yes.
Peter,
Yes.
Rebecca,
Abstain.
James,
Yes.
Chris,
I'm gonna go no.
Roberta,
Yes.
Vivian,
Yes.
John is out, Catherine,
Yes.
Brian,
Yes.
Steve,
Yes.
motion carries 8. Vote in favor.
And how many against? Just.
Well, there's one against and one
abstain.
two, I'm sorry, 2 against and 1 abstain.
Yeah.
We're making progress here.
Absolutely.
Thank you, Pete. I think we need that encouragement. No, it takes time to go through this. These are not easy issues. And there are a lot of perspectives, and this is with respect to all, we respect all the differences of opinion here. We're trying to come up with something that works, that, the majority of us can at least provide through the legislature to help provide some guidance. I'm trying to look to see if there are any other
Yeah, Jim,
easy issues.
Jim, I just noticed, I did have on page 10 that, where you changed everything from ways to, from private ways to
Yeah.
public easements. In 1A, right on the second line, you missed where it said ways. Probably should be changed to public easements, and then down at the end of C,
Oh,
way,
Yeah.
public easement.
sorry about that. Okay.
where was the second one, Roberta?
Those are,
Paragraph C, the third,
Yeah,
the
sorry,
end of the
should
second
look like
line
that
down to
one.
the third line
Got it.
on page 10.
I will make that change.
Oh, right.
Are there other changes? Well, actually, there's one I think that would make the most benefit. Page 11, section 10 on the legislative changes. Right now in state law, state highway and road law, there's a definition of private way that I think creates some confusion because it says a way privately owned and maintained over which the owner may restrict use or passage, right so far, and includes a discontinued way even if a public recreation easement has been reserved. So you're now completely confusing everybody.
Yeah.
Because we're using, private ways defined differently to mean what's now a public easement, and you're saying it's private, even if public recreation easement's been reserved. My proposed change here is repeal it. Use the term private road, which means a way privately owned and over which the owner or owners may restrict access and passage. And use that in place of the term private way where you're referring back to this definition. I think that part itself is an easy change. What that requires, though, is that you then have to find all of those provisions in Title 29A that talk about a private way as defined in 29A, Section 101, Sub 58, and change those over from private way to private road.
Wasn't that section of law written because of like Walmarts and Hannaford's and where they're trying to be able to control and enforce behavior on, you know, parking lots and things that are not actually roads? And if you change this to a road, won't you unintentionally screw up police's ability to do enforcement?
Well, if you're worried about being able to enforce the public easement that's adjoining the private road, you can say public easement.
Well, I'm not so much like, I'm wondering if you shouldn't leave it the way it was and say private way, and then just, you know, do away with including a discontinued way, even if a public recreation easement has been reserved. I think changing the term private way in this scenario to private road potentially eliminates that, because somebody will look at a parking lot and go, this isn't a road.
So the idea would be that if you're in Title 23, a private way means public easement, but if you're in Title 29A, a private way means a private road. It means a private road, not a public right. That's basically what you're saying. I'm not saying that's right or wrong, but that's what it would mean.
Saying my outlook is, I don't think this section, the way it's currently written, not your writing, their writing, should have included a discontinued way, even if a public recreation easement has been reserved. I think you could eliminate that and get rid of some of that confusion. What I am unsure of is whether or not changing public way to public road in that scenario may create a situation in court where they'll argue you can't enforce this in a parking lot because it's a road and a parking lot's clearly not a road.
Now, that's where I had suggested at one point that maybe we need to have a statute that specifically says that law enforcement has the authority to enforce the law in private areas, including parking lots. I had some language for that somewhere. I don't have it in front of me right at the moment, but I'll find it again.
Well,
Chris, you probably know more about that than we do.
So Title 29 is about motor vehicle operation. There's only a few crimes that have enforcement authority over private lands. The rest of that statute is about operation on a public way.
Hmm.
So these wouldn't be enforceable on a private road. The vast majority of them aren't. It's the problem comes into play when there is a public expectation of operation where it can happen in those spaces, like what Brian had said.
So we can't eliminate the and includes a discontinued way, even if a public recreation easement has been reserved.
Well, I think that gets at the intentional damage issue.
Because
but this whole section of law wouldn't apply to someone who's trying to sort out what their road is. I think that is what the source of confusion. You wouldn't go to Title 29 if you were trying to determine what the status of your road was.
Yeah,
Title 29 is exclusive for motor vehicle traffic enforcement. So there really shouldn't be any confusion. You're looking in the wrong place if you're looking at that section.
I still think it's confusing.
But this is about the person that has to enforce the law, understanding where they have the right to enforce the law and the ability to enforce the law.
Didn't we
Yes.
ask law enforcement for an
Yes.
opinion on it? And they
We
said
did.
they didn't have a problem with it?
No, they said it was their opinion that it wouldn't cause any issues at all. Have the letter.
That was from the major, correct?
Yep. Colonel Ross.
Oh, it's from the colonel.
Yep.
I think he had a lieutenant look at it, didn't he?
Yes, he did.
Yeah, Lieutenant Scott.
What was it he said wouldn't cause an issue? Have we changed it or? have we left it
So
the same?
what we did we sent him the changes to 17, 17A and 29A.
I think he pointed out two sections, right? I think there were two sections in there that he mentioned. If I remember correctly.
Okay, let me read the letter back. So the email back was from Danielle and she said, "Good afternoon, Maine State Police. does not see how these subtle changes could have a negative impact on law enforcement. Lieutenant Scott reviewed and researched these recommendations and would support them. The term private way is only used in 5 times in 29A, and changing the term to private road while using the same definition has no effect. The recommended changes to Title 17 and 17A would indeed add some clarification for law enforcement officers. As a matter of consistency, I'd recommend that the following also be changed. 29A, section 20 through 2382, construction permits. A permit for a stated period of time may be issued for loads and equipment employed on public way construction projects, United States government projects, or construction of private roads instead of way. Until the Maine State Police receives and reviews the actual bill language, which would be from the legislature, and then runs it through our legislative process, we can't provide an official agency opinion.
Now, you read there at the beginning, though, that they said changing private way to private road with the existing definition created no problem. We're talking about changing the existing definition.
By deleting off the and includes a
Yeah.
discontinued way, even if the public recreation easement.
So I think at the very least, you should run this back by them.
Wasn't that what I submitted to them though, or no?
I think it was, I don't.
I think that's exactly what we already submitted to them. That hasn't changed. I submitted to them all of our summary of proposed revisions to Title 17, 17A, and 29A.
I'll tell you what,
These are.
making this change, if, whatever we do, whether it's just retain the term private way and lopping off the and includes a discontinued way, or substituting the term private road for private way, does require a bunch of changes in other sections of 29A, 17, 17A, whatever. And we probably in the next, I mean, we've been here for 3 hours now. We probably don't have time to run through all those today. Does it make sense to put that in the parking lot as well to make sure we don't, the law of unintended consequences does not happen here?
So moved.
We're in the parking lot on the private way.
All right. We have those items that we have worked on. I think we've gotten a fair amount done at this point now. What I can do is edit the report. Just focus on those that were approved by motion today. By majority. I would ask that those who dissented, objected or abstained, if you'd like to submit your comments to make sure they're part of the mix, because this is a policy matter. There's no right or wrong, there are different opinions. Please get that to me. Gosh, Christmas is Monday, we've got New Year's a week after that, and it's 2 weeks from today, the report's due. And do we want to meet again by Zoom to vote to adopt the report after everybody has had their input?
Yeah.
If we have.
We probably should. If we're gonna do that, let's just do January 5th, which is the, is that?
Who's going what on, is it?
I can't think of anything better. than that.
Yeah, no.
Are we, on something like this, are we not allowed to, do we have to get together to vote? Or can we vote by email? Could we vote by a doodle poll, or just a question?
No, Freedom of Access Act, we have to deliberate and vote in public. So, but we can do that by a remote meeting by Zoom, which I would strongly recommend under these circumstances. Let's say that we were to have a meeting on Wednesday, January 3rd. I believe that's 23rd, right?
Mhm.
Versus Monday.
Yes.
Okay, Wednesday, January 3, we meet at, let's say noon, so we don't cut into people's schedules too horribly. And we do it by Zoom, which means I have to have a draft to all of you,
You said what time?
say noon time, so that, you know, you could actually off camera eat a sandwich while you're considering and voting. Means that I am going to need to have a draft to you by Friday. What's that, the 31st, 30th, the 29th? I'm setting myself up here. Friday, the 29th, I have to have a draft to Heather to give out to you. So
Yeah.
on Thursday, by the close of business, Thursday, the 28th, anyone who has objections, comments that need to be included in the report, please get them to me. Is that, I hate to throw other people a, tight deadline, but I'm working with one too.
Heather, can you please send us an email on that, with that in there?
Yeah, yeah, you want me to, we mean with the deadline the
With the
28th
schedules,
and the, yep.
Yep.
So deadline Thursday, the 28th, close of business to me, and then I will feverishly incorporate that for Friday, the 29th. I will get that to Heather, who will then send it out, so everyone will have the weekend, albeit, New Year's Eve, but you'll have the weekend. to think about it. And then if we have that meeting Wednesday at noon, that means that if there are any last minute changes that need to be done, Heather and I can work those through to have the report done and hand it in on January 5th.
Before we finish up here,
Yes,
one thing that seems to me like it ought to be pretty straightforward. On page 13 of the draft, failing to stop snowmobile before entering a public way and failing to yield right of way while operating a snowmobile. It says, must come to a complete stop before entering a public way or a public easement maintained for travel by the municipality. And it seems to me the issue is not who's maintaining it, the issue is whether they're going to be meeting motor vehicles on it. So if it's maintained by either the municipality or the abutters, if it's maintained for motor vehicular travel, they ought to have to stop and they ought to have to yield.
yeah, and I believe that's one of those ones where it now says private way. And I made the change and it didn't go through in legislative style.
Yeah, it just says public way or a public easement.
Yeah. Does
But
it?
if they could say maintained for travel and cross out by the municipality, or maybe say maintained for motor vehicular travel. So I think that was, I think Brian brought up, does that mean if it's maintained for travel by snowmobiles? But to make clear, the issue is when there's a conflict between use by snowmobiles and use by motor vehicles, you don't want them colliding each other because that's not a fair fight.
True enough, but do we want to just, I appreciate that this might have a simple solution, but it's in a bigger context. I think we might want to just wait and hope that no one gets hit in the meantime.
They're going to, but we'll clean up the pieces.
Thank you. Wait, after you, no, I'm not gonna go there.
Yeah.
They're going to, but he'll pick up the pieces.
All right.
Thanks, Chris.
So are you saying that the report's only going to include the things that the majority were in favor of and the other things won't even be referenced in the report unless somebody else writes it? Correct?
I think probably what we can say is that there are several other issues, and I can very broadly describe what they are and just say that these will be further considered by the committee. We didn't have time to go through everything. Or we didn't have time to reach agreement. And we will continue to work on those items and report back.
Right, I think that makes good sense. That way they at least know that we talked about this stuff.
Right, we haven't been misusing taxpayer dollars.
Right.
That's for sure.
Okay.
All the food we've had was brought by others.
And I'd be remiss if I didn't say, Catherine, thank you for this afternoon snack. I appreciate it very much.
They're yummy.
We had a good couple bake sales.
Yeah, we'll leave bake sales for snacks next time. All right, if there's nothing else, is there a motion to adjourn?
Oh, so moved.
Second.
Second.
Okay, let's not do a roll call. All in favor, aye.
Aye.
I
Oh, aye.
Thank you all very much.
Thank
It'll be
you
really
all.
cold out.
Thank you.
Merry Christmas and Happy New Year.
Same to you guys.
Happy
Yeah.
holidays. All, thank you.